Our next speaker is Joe Krasovec. Joe is a litigation partner at Schiff Hardin in Illinois. Joe's focus is on product liability defense. He is a cum laude graduate of the University of Denver and a graduate of Northwestern University School of Law. Joe has participated in more than 30 mock trials and will speak to us today about those experiences. Please welcome Joe Krasovec.
Thank you, Philip. Good morning, everybody. Philip mentioned I'm from Illinois. I'm from Chicago. We have the Chicago Cubs, and we are a feeder team to nobody, because that would mean that somebody would want the players that we have in Chicago. And usually by about this time of year, we are almost mathematically eliminated. So I'm going to talk to you a little bit today about mock trials. And I know I'm speaking to a room full of lawyers, and what I'd like you to do is take your lawyer hat off for a minute and put your salesperson hat on and think about things in terms of a sales perspective. And when a salesman thinks about what he has to do, he thinks about, or she thinks about understanding who he's selling to, identifying what motivates those people, and then crafting a message that will reach those people to convince them to buy their product. Marketers use focus groups to do this kind of thing. Lawyers use mock trials, and focus groups are prevalent. Many of our clients use them readily. Coke spends over $3.6 billion a year supporting its brand. It spends hundreds of millions of dollars a year on focus group. Procter & Gamble, over $150 million a year in focus group spend last year. This is how these companies, our clients, figure out what motivates the people that they're selling their products, they're selling their services to. And that's what a case is like. A case is like a product. Your jurors are your consumers. You want to package your case so that you create the most likelihood, the best package to get your jurors to buy your product. In essence, you're a salesperson, 8, 10, 12 people at a time. And just as a consumer chooses whether or not to buy a product, a juror's decision is just as binary. They're either going to choose your case, your version of the facts, your theories, or they're going to choose your opponent's. So what I want to talk about this morning is how to go about creating a mock trial, a focus group, the lawyer's tool to assess the message that you're going to send and package that message, how to do that as economically as possible, and then how to use it as effectively as possible as you prepare for trial. Okay, so just to make sure that we get on the same page, what are we talking about when we talk about a mock trial? I suspect many of you in this room have been involved in mock trials or have seen reports regarding mock trials. When I talk about a mock trial, and those that I've done typically involve anywhere from between 30 to 45 people, panelists, that are chosen of the same demographic as the jurors that will be in your venue. It's generally a one-day, sometimes two-day, truncated presentation of evidence, usually something akin to an opening statement. Then the panel is divided into individual juries, and those juries deliberate, and that's where the rubber meets the road. That's where you get the meat from the mock trial. It's moderated or conducted generally by a jury consultant and can cost anywhere from $40,000 upwards to over $100,000 to conduct these exercises. I'm going to talk to you a little bit about how to stay down toward the $40,000 range and yet get the most out of, get the $100,000 bang for your buck. So let's get a couple of nuts and bolts out of the way, the legal issues. And really the only question is legal issues with respect to mock trials or confidentiality. It's not complicated. They're generally protected. They're your protected work product if you conduct it. The jury consultant's reports and opinions and communications with you are also protected because that consultant is considered a non-testifying consulting witness. The one thing to keep in mind is there are a couple of cases out there that have held that an individual witness who was going to actually testify in the trial, a testifying expert or a fact witness who physically participated in the mock trial, had been compelled to testify about their observations during the mock trial. So, and we'll talk about it in a minute, but when you're going to have live witnesses, think about whether those witnesses are actually going to testify at trial and whether you might not want to have them there or not have them there for certain portions of it, or present their testimony by videotape. Picking the consultant. Two really important points here, I think, are, and this is a cost savings, some consultants will sell you sort of a real-time feedback mechanism. And what that basically is each of the jurors is handed or a panelist is handed a dial. When they're listening to presentations, one half of the dial is favorable, the other half is negative. They will, as they're listening to presentations, turn that dial to reflect what their opinion is of what's being presented. It's then usually split by gender, and as you're watching, if you're watching backstage on a closed-circuit TV or on some other medium, they'll graph how the people are responding by gender to the arguments that are being made. I've never found that particularly useful. It tends to cost a little bit more, so that's something that I generally don't use. The other thing that's important is to make sure that you pick a consultant that has some experience in your venue, because you want somebody who's going to know the demographic, and as they're selecting the panelists, they make sure they've got a good cross-section of a pool of panelists that will reflect your venue and give you a lively debate during the deliberations. Who do you have attend? You want your key decision makers there from your client. You want them to hear what these folks are saying about the case, because that's going to invest them in the decision of whether or not to go to trial. You obviously want your lawyers on the team, and you want to make sure that the jury consultant that you're going to use to actually pick your actual jury will be there also, because you want them to have the experience and see real time everything that's gone through. Believe it or not, I've had some consultants where the person who did the mock trial wasn't able to show up for the actual jury selection, and that hinders their ability to be effective in that regard. Presentations. Again, you can do 1 or 2 days. I've generally always done 1 day, and you can get it done. You can do the presentations in a morning. Hour and a half, 2 hours each side. Whoever has the burden of proof, give them 20 minutes for a rebuttal. Documents and physical evidence, very important to try to get the important documents and physical evidence in front of the mock jurors. Let them assess it, let them see it, let them handle the physical exhibits if they're important. Witnesses, again, with the issue of having a live witness who might testify, you want to show deposition video. If they haven't been videoed, do a little videotape. You want the jurors to be able to assess the physical presence of your witnesses. Who plays the other side? So you're all there, everybody, your team's there, you're all drinking the same Kool-Aid. Who do you want to have play the plaintiff? And I think a great strategy is to have the lead lawyer on your team play the other side. It forces that lawyer to get into the shoes of the opponent, to understand the opponent's case, the strengths and weaknesses of the case. Somebody suggested it to me a few years ago, and I found it invaluable as part of my trial preparation. Plus, then you get a really good, lively debate from the jurors, because you don't want an imbalance in the presentations. Videotaping the presentations, not typically. I don't see much value to it, and all it does is add costs. Issues to present: test as many theories as reasonably possible. Don't present clear winners and losers. You want, again, a lively debate. Be honest about your case. Tweak it if you need to. You don't want garbage in, garbage out, so you got to be honest about the case. But tweak it so that you make sure that you've got a balance of evidence on both sides. And then deliberation. So once the panel is heard the presentations, they're split into usually 3 to 4 different juries. You want a good mix of jurors. Your jury consultant will help you mix up the individuals based upon surveys that they might be doing during the presentations. And what you want to do is now start to identify who your high-impact jurors are. With respect to damages, I never take whatever damages numbers very seriously. I think the truncation of the presentations just doesn't give the jury enough real information to assess damages, and so I generally don't pay much attention to that. After it's all over, the consultant will issue a report. What do you want out of the report? You really want three things. You want to identify the profile of the jurors you want, and you want the profile of the jurors you don't want. You want to know their demographics. What do they do? What are their proclivities? That's how you're going to create, if you have the opportunity to do a jury questionnaire, those are going to give you the questions to put on the questionnaire, so you can start to tease out the traits of the people you want and the traits of the people you don't want for possible strikes. The consultant should give you some sample voir dire questions, again along the lines of teasing out information that's going to tell you whether you want to strike a juror or you want to try to keep them on. You want to chart the good and bad themes, the successes. What are the themes that resonate? What are the messages that are selling your product, and what are the messages that don't? Anything more in a report drives up the cost and pushes it toward that $100,000 mark as opposed to the $40,000 mark. Okay, so you've done your mock trial, and you've got your results, and now what do you want to do, or what do you do with all that? How do you maximize the information? What I do is, before I go to trial, I go back and watch the videotapes of every one of the deliberations, and what I'm looking for are the high-impact jurors that are on the pro side, that are for me, and the high-impact jurors that are on the negative side. And I try to identify them, and then I go back and I look at their demographic, and that's how I'm going to model my voir dire to determine who I might want to strike. So I'm going to play some clips for you from a mock trial that we did about 3 years ago in Texas. Just real quick setup, the case involved a high-speed motor vehicle accident. I represented a company that manufactured a child seat. There was about a 3-year-old boy in that seat. It was a booster seat, so it meant that the child was sitting on the seat but using the vehicle's lap shoulder belt, and the child had suffered a bad neck injury and was a quadriplegic. The reason that he was a quadriplegic is that he came out of position, went too far forward and stretched his neck, and it caused a spinal injury. So the big question in the case was, where was the shoulder belt? We contended that the shoulder belt had been put behind the boy, that he was wearing it behind him. The plaintiffs contended that something on the seat broke, and that allowed the shoulder belt to move out of position down on his arm, which allowed him to go too far forward. Okay, so the first clip you're going to see is of a juror who was a high-impact juror, negative for us. This is, you'll see her, she's off to the left-hand side toward the back of the room.
You know, I started out, when I was first watching it, you know, all for the little boy, you know, sympathy for him and stuff, you know, which I still do have. But the fact somebody just got through saying it, you know, he's the only one that got hurt. He was the only one that was sitting in the seat. And I do believe that that the seat was defective. They have fixed the problem now, so it could have been fixed then, I believe. I believe the seat was defective and
Okay, so this is a juror that's clearly in the side of the plaintiff. Sympathetic to the child. The child was the only one who suffered this level of injury in this accident. Believes firmly, as you heard, that the seat is defective, and that's what causes his injury. So she's firmly in the plaintiff's camp, and there were other deliberations where she makes other arguments to the other jurors about why the case should be decided in favor of the plaintiff. So now we've got to look for who is our high-impact juror on our side, who is our champion in the jury room, and what do we need to do to arm that person to convince jurors like this woman to flip over to the other side. Our high-impact juror is the fellow with the blue shirt, no hair, looking like he's riding something. So here's our first indication that he's a high-impact juror. And let me set this clip up just for a second. This is one of the witnesses that the plaintiffs produced said he'd driven by the car just before the accident happened. The child was sitting on the passenger side, on the right side of the vehicle. He's driving next to the vehicle. He says he looks up and sees the shoulder belt on the child's shoulder. So he came in and testified actually that that's what he saw. So we knew we had to attack that witness's credibility, and so part of our presentation was to do that, and so we want to see how that resonated with our high-impact juror.
To the topic of discussing whether or not Jason, and let me just say right now that Jason is by far the greatest tragedy of all of this for me. I mean, I don't think any of us, our hearts are not just breaking for this child. But I go back to, this Bobby Jackson that was, eyeballing this woman driving down the road.
Yeah.
I mean, he wasn't, well, I got another term for it, but I'm not going to put it in the recordings.
Be nice.
But at the end of the day, I don't know if I'm the only one that noticed this, but my 8th note underneath the plaintiff, when they brought out there, I put down witness demonstrated shoulder strap coming from opposite side. He showed us the way that strap come across that child like this, which in order for that strap to come across that child like that, from his left shoulder down to his right hip, would have put him on the driver's side of that vehicle.
That's right.
When we already know he's on the passenger side.
So he's not credible.
So either he's too busy eyeballing mama, or he's, I don't think he's got a dog in the hunt. I think he's just trying to be a good old boy, but get your facts straight.
And I forgot to tell you that the mother of the child was a very attractive woman. So one of the things that this witness noticed is that's the first thing he noticed was how attractive the woman was. And then, of course, he happens to see the child, but he has the belt going the wrong way. And so that was the first point that we put out there for our high-impact pro-defense jurors. He picks it up, and you can see how he's already starting to convince people. You're seeing the heads nod. So we know that that's an important point in our case to really attack the credibility of this other witness by emphasizing that he's got the belts going the wrong way. It would put the child on the other side of the car. The other big issue in the case was the child only had one significant belt mark, and it essentially ran across his stomach. There was nothing over his upper torso. Plaintiff's explanation for that was, well, it just loosened when the car seat broke. Once the shoulder belt loosened, it wouldn't make as big of a mark. We emphasized the fact that there was only one belt mark, and therefore there should only be one belt.
Viewpoint, what they're asking us to decide is Graco responsible for the injuries to this child?
No.
Now, to me, the only way I can hold Graco 100% responsible and say, Graco, your product was defective and you're responsible for these injuries, if I see that child, Graco can, in my opinion, can only be responsible if and only if that product is used in the manner in which it was designed. And I'm not sure, first off, I think mama needs to understand who was the adult, who was the 5-year-old.
Yeah.
But, him deciding what kind of restraints. But at some point, an adult has to be an adult.
That's right.
And they have to take responsibility, and they have to turn around, and they have to, okay, Junior, make sure you keep that on, and if Junior don't want to keep it on, do what you need to do to make sure Junior's in compliance. At that. But, I took some other notes over here. I know somebody made the comment, I don't know who it was in there, but when you hit your brakes and you start to go, those belts will lock in that vehicle.
Yes, you do.
If that belt is across that young man's not coming. If that young man comes forward and that belt's there, he's going to have a mark. It may be a slight mark, and I don't think it's going to be a slight mark. I think it's going to be a pretty distinguished mark. But I'm not a medical professional, but I do know myself. I carry something over my shoulder for any length of time. I wear overalls a lot, when I'm out working. When I get undressed, get ready to shower, I can show you where that overall was. And that's not a trauma.
Did you see the color of the one across his waist?
Exactly.
I mean, that tells you, to me,
That's where the load went.
That's where 100% of the load went. If he had had that strap across here, it would have been That mark, that was, oh my gosh, that was a huge, deep bruise.
So now you can see how our high-impact juror has picked up another high-impact juror that's echoing the same thing that he's saying. And what we need to do is emphasize those marks. We brought in medical testimony to show exactly where the marks were, and then lined it up on a surrogate to show how if the shoulder belt was being worn, there had to have been a mark on top of the shoulder. Ultimately, when this jury first started deliberating, they were 6 in favor of the plaintiff. I think there's 9. There were 3 who were pro-defense, 6 who were pro-plaintiff.
I guess the question we really need to ask ourselves right up front is, does anybody believe that the design of Graco's car seat caused the injury to this child?
No.
Anybody with
You got
yes?
no? John?
Everybody
No.
agrees unanimously?
Amanda?
No.
Terry? Paul?
I'm thinking.
Okay.
No, I don't.
Debbie? Donna?
No.
Seven?
No.
No.
So now he's got even the high-impact pro-plaintiff juror over to his camp. So by looking at these deliberations again in trial preparation, we were able to order our proof and emphasize the proof that armed the high-impact juror to convince the other jurors to come over to our side. We actually tried the case, and there was a defense verdict in the case, based really largely on how we put the case together from the mock trial. Thank you for your attention. I hope you enjoy the rest of your day here.